Zoning Board of Appeals work session, Tuesday, September 14th, 2021. And Susan, yes, let's talk about when we can meet in November and December.
Are you had told me maybe you could just move it back a week, forward a week, back a week.
Well, so in November, would everybody like to meet on the 16th and the 18th?
Sure,
Does that work for you?
it does for me.
Okay. And Joyce, would meeting on November 16th and 18th work well for you?
Yes, that's great. Yes, thank you.
Okay, and that,
Mr. Chairman, Mr.
Yeah.
Chairman, on the 16th, I'm in Village Justice Court, but I could get coverage. It's the 18th that I may have a conflict because I have a different Villages Board of Zoning Appeals hearing that evening, but they don't always meet. Why don't we go ahead and schedule? I can get coverage for both. I'm just thinking this through. So if need be, I can get coverage for both if that works for everybody.
Do we need him for the work session necessarily?
yes, I think so.
Okay,
Yeah, and I appreciate, I'll get coverage for both.
And then would we switch the December meetings to the 14th and the 16th?
I
Would
would
that work
not
for
be
everybody?
available. I would not be available on the evening of the 16th. But you can certainly all go along without me, but I just need to let you know that.
Joyce, would it work for you, the 14th and the 16th of December?
Yes, that's fine. Too.
so I'm good.
Okay, then how do we find out if there are any conflicts with any other meetings? But if we have Zoom, Cat, which we will, do we have any conflicts that you know about on either November 16th, November 18th, or December 14th or December 16th?
There might be a trustees meeting.
Kat is not in the meeting right now, but we can double check that.
Okay, Jolie, can you double check that? And if it's okay and we're not in conflict with other meetings, then we'll move our November meeting from the 23rd to the 16th and the public hearing from the 25th to the 18th. And in December, we'll move the work session to the 14th and the public hearing to the 16th of December.
Okay, I'll double check that and I'll let you know.
And I can confirm, Mr. Chairman, that I'm available for all of those dates.
Okay, excellent. Thank you, Chick. Okay, and then we can go to a review of the decisions with respect to case number 3106. Are we ready to write the decision on that?
It has been prepared.
Okay,
We reviewed it last month, but then the applicant submitted a final document. But my understanding was that it did not change the written opinion, the written decision that had been prepared. Is that everybody else's understanding of it?
I don't know about what they submitted. I know there was a discussion about a compromise 1 foot, which we didn't agree to, right?
Correct.
So it's still a 23.
Mhm.
okay. With respect to 14 Gin Lane, case number 3111, Jeff, can you bring us up to speed on where we are? I think I understand that the applicant needs to, one way or the other, obtain a coastal erosion hazard line permit, and that they have requested the permit be issued by the building department, but the building department may have informally said that they will not which would call for the applicant to appeal to the Zoning Board of Appeals for a coastal erosion hazard line permit. But while that's been informal, we don't have a formal denial from the building department. And so we do not have this right now ready for decision, and we may resubmit and re-advertise. Is that my understanding? Is that your understanding, Jeff?
Well, Mr. Chairman, what I'd like to be able to do, Mr. Voorhees was kind enough to speak with me along with counsel for the applicant. I received an email from counsel for the applicant yesterday afternoon, which I shared with you. I'd like to follow up with counsel. I think we're really at a procedural question that we should be able to work through. And the question is whether or not the applicant believes a permit is required, and if they're, I think they're willing to proceed with pursuing it through the building department, but I did want to speak to Mrs. Sato further because I don't want to create difficulties for them. We just want to work through the process. And I will also speak with Mr. Tin-Ho to confirm that. So that's a longer answer than you probably needed, but the decision, I would suggest we hold off on until that's clarified, and I can follow up with counsel about that. It should not be a very long time frame.
Does
Okay,
that
so-
mean it might be for the real meeting? This is a work session.
I don't think it will appear at this
No,
point at the public hearing.
It will not.
It will
But I-
not.
Okay.
Do we agree, Jeffrey, that it will not appear for the public hearing?
I agree.
And then case number 3105, 99 Sanford Place. I think, Jeff, you may be ready to
Yes,
write the
I've
decision.
forwarded. Yes, I've prepared a draft, which I forwarded for review of the board. And if members have questions and discussion, I can follow up with all.
And with respect to case number 3107, I think we're also ready for a decision, 75 Hetty Creek Lane.
I think that's correct, Mr. Chairman, and actually that would be both for 3107 and 3114, which would be Captain's Neck. And with respect to each of those, I hope to have draft decisions for the board's review during the weekend. There's Yom Kippur in between, and then I should be able to have those available.
To summarize, we'll have 4 decisions at our public hearing on which to vote. Case number 3106, case number 3105, case number 3107, and case number 3114, and we'll be holding off on case number 3111. Is that accurate?
Yes,
And just to
Yes,
add,
Mr.
Mr. Chairman, 3107, there's also a wetlands decision. And I wanted to be sure that the board wanted me to include that decision for approval as it was presented in the plans. The wetlands issues were really the minor issues because the setbacks were greater than the actual house itself. They were opposite, the wetland area. So I can draft that as well and have that ready for next week's meeting and for early review well prior to the meeting.
And what's the question for the board?
No, just if the board is comfortable with the plan as prepared, I would prepare a decision based on those most recent plans.
Okay, Julia, are you comfortable with the
I am.
plan as presented? And Joyce
Yes, I am.
and Susan?
As far as the ZBA goes, yes.
And as am I, Chick. So yes, go ahead and do your work.
Thank you.
Under pending cases, case number 3104, Town of Southampton, 51 Pond Lane. I believe we have a letter of adjournment from the applicant.
Mark, I
That's
had a
correct, Mr.
question,
Chairman.
which, because that arrived this afternoon based on the date of it, I believe. And what is it that we decided in terms of adjournment? Because this is the second one in a row. And my understanding had been that once we got to there, that it was a different process.
Mhm.
I
Yes.
believe under the resolution, which I don't have in front of me and should have, I believe that they're allowed to request two adjournments. And ideally, they would put those requests in, I think, 72 hours in advance. In fairness to applicant's counsel, I spoke with him over the past 2 days, I think yesterday and then again today. So he had to get back to his client with some questions that they needed to address. So I think that's why it may not have come before the board until today. And I think they referenced that there's pending local law that's being considered by the Board of Trustees that may in fact impact what would remain before this board.
That's true, but until it's passed, I feel like we're supposed to do our job. I don't know. If that's the excuse, that's fine. If it's two adjournments, is it only two?
This
I
would be
believe
the
that's correct.
second.
Yes, I think this would be the second request for an adjournment. And the last being,
Last
forgive me,
time.
I'm forgetting the date. But this is the second request for an adjournment.
So I think Julia's question goes to what would happen if a third adjournment request came before us? One thing I remember is it would have to be presented in person. But
And
The request.
And then I believe whatever the determination of the board would be, while I would certainly be within the board's discretion, new notice would be required. Whereas with the first two, I believe the requirement of notice was a discretionary thought with the board. The board could always order new notice. But with the third, I think it was something that this board wanted to have mandatory.
Julia, does that work for you for now? Does that response
Sure,
work for you for now?
sure. I just wanted to be certain that the decisions that we had made about the adjournments, that we were staying in pace with them. Because it's a relatively new set of requests.
Yeah, and this request needed to provide a written explanation as to the reason for the adjournment, which it did.
Okay.
So then we go to case number 3110, 54 North Main Street. And Jeff, can you bring us up to speed on where we are with 54 North Main Street?
I can, and some of the issues are legal in nature, so I wouldn't want to put too much on a public record, but what I have received is a memo from the environmental consultant with the planning board. You'll recall that I think I'm causing the echo. Is
You are.
everybody able to hear me? Oh, let me see what I can do about that. Is this any better?
Much better,
Okay.
much better.
Thank you. You'll recall there was a question about whether the planning board would wish to consider permitting an easement as opposed to the grant of a variance through the BZA for the creation of a flag lot. The environmental consultant with the planning board has prepared a memo, which in sum and substance indicates that the planning board in their thought process would prefer a land use grant or a variance grant in terms of carrying forward into the future. I have placed a call to Ms. Alice Cooley. She's counsel to the planning board, and I'll be speaking with her as well. But that is the response that we received when I checked with the consultant. I also had the chance to speak with her. So I do want to follow up so that I can speak directly with their counsel as well, and then advise this board accordingly.
Well, where's our, I thought Mark, our feeling is that we would prefer not to grant variances if we don't have to. No?
Oh, understood. The board has before it an application for a variance. the question I was asked is if the planning board was of a mind to perhaps consider the other alternative, which had been before it, which would have created a similar, I'm summarizing, use of the properties, but with an easement in place of a variance in terms of one of the aspects of the request.
Wasn't that our preference that we stated?
Yes, it was.
Yes, because if they employ an easement, then the applicant avoids a request for 3 separate variances.
And that's our position, correct?
That was my suggestion. Do you agree?
Yeah, that's why, you know, they've got their opinion and we've got ours. That's the way I see it. I don't know if that's been, I mean, I don't feel that we need permission from them to have a different idea, which is one that was actually stated but denied, right? By
It
the
was brought
plan,
to our attention by the applicant's attorney or the substitute attorney, is my recollection of it.
And that for whatever reasons, the applicant actually preferred, and Jeffrey could, correct me if I'm wrong, I believe the applicant preferred to have the easement approach.
I don't recall that, Mr. Chairman.
That
I
is
thought
the memo, that is what the memo states.
Mhm.
That's what the chairman just recited.
So anyway, to Susan's point, I don't think we want to issue a decision where variances are unnecessary.
so how does this work? We just say no?
Well, in terms of the deliberative process, that will be on for the public session, and the board would be deliberate and make a determination.
But I feel like what you're telling us is that all these other boards are telling us what to do, which I don't think is what we should do what we think we should do. No?
No,
Well,
absolutely.
yes,
This board.
and quite frankly, Jeffrey, I don't want to inconvenience the applicant, and I don't want the applicant, to feel as if they're being, kind of shuttled around. We would not want to grant 3 different variances where they're unnecessary. So we really think this should be back before the planning board for discussion as to whether the planning board, knowing our position, would now grant the requested relief or the approval for a subdivision with an easement. I think it needs to go back in front of the planning board, their full board, before we consider it any further.
Okay.
But okay, so we're going on to 88 Hunting Street, which we've not yet heard presented, which is case number 3112. Should we wait to see if they present at the next public hearing? I think they were discussing the
I think
variance
that-
request with one of the
I think
neighbors.
that's the proper thing to do because they haven't actually had an opportunity to present it, nor have the neighbors had an opportunity to join our meeting and discuss it.
So why is it considered pending as opposed to being a new case, since we haven't heard it? Is it just an error?
Yeah,
And I know it came up before and we were told that the owner, the applicant wanted to speak with the neighbor before they came before us, but if we haven't heard it, isn't it still a new case?
it hasn't been presented, correct?
Yeah,
Yeah,
I think you're absolutely right. They
right.
adjourned it. It should stay on new case. Jeffrey, can you correct that with Jackie in the building department?
Sure. The only thought I would have in terms of it being pending is that they've had one request for an adjournment. And then a further request would then be the second if it's pending, but
Right.
they certainly have not presented.
So how does that work? I'm confused, actually. So if you ask for an adjournment,
I would,
adjournment, but you haven't actually presented your case. I guess that's adjournment number 1. I just don't know how it would be classified. It's not pending because we haven't listened to it. But it hit, I don't know. I don't know how they classify anything. they
I would actually suggest classifying it as pending because they did appear before the board. They did make a statement and explain they were requesting the adjournment.
Does
Did
that work
they
okay
appear
for you,
before the
Julia?
board or send a
Sure.
letter to the building
Just didn't
department?
understand it.
I agree. It's right. It is, well, it's
It's
confusing.
messy.
Well, it's confusing to have an adjournment, and this was adjourned once before in July where they basically withdrew and re-advertised. So,
I see.
but let's keep it under pending cases and perhaps we'll hear it next Thursday night. So under new cases, we have one new case, which is 143 Herrick Road. And I mean, this is one case for discussion among the board members. I think the variance request is minor and we might see that we can grant the variance, but I think relative to the variance request, the presentation to the Architectural Review Board is more significant, more substantial. And I would like the applicant to go before the ARB before they appear before us. I'm not sure why they're coming to us first.
This is one of the landmarks in the village of Southampton. It's one of 5, like the Halsey House. So I agree with you that the changes are really about a historic property. The amount of variance they're asking for is so minimal. But it would depend on whether or not the ARB will allow a change in a landmark. Before we get this, I think you're right.
Well, and I'd rather see that the variance we're granting, if we grant it, is the same presentation that's being approved by the ARB. So it just seems like that we're not in the right order, that they should go before the ARB before we hear the case. Joyce, do you have any thoughts about this?
No, I mean, from what I know, I would agree that it sounds like they need to present to the ARB before coming to us, to the ZBA.
So Jeff, how do we procedurally coordinate that and have the applicant go to the ARB first?
Sure. With the board's permission, what I can do, certainly it's their application, and if they wish to proceed before the ZBA, they will be permitted to do so, but perhaps I can reach out to the representative and discuss the board's thoughts and see if there's not, if they can proceed in a different fashion.
Sometimes when I worked on the ARB, there was like an advisory. They could be consulted. They might not have to hear the whole thing. That's what we do sometimes, but I don't care. But I agree that the actual question is about how the outside of a landmark looks, not about 27 square feet or whatever it is. It's a change to the entrance, I believe.
So they have an architectural consultant now to the ARB. Who is that? Do we know, or
No, do they?
I don't know.
Zach Studenroth,
No, he's not
No.
worked for a
he's
year.
gone. Okay.
He's historic.
Oh, he is historic, yeah.
No, but he's not, he quit. He's gone.
Our,
Sag
our
Harbor.
office has been asked on a case-by-case basis. We do have in-house architects, but I don't know if it's on every application at this point. I think it's just by request.
Well, one member of the board of the ARB is an architect, if you want to know the truth. He's retired.
Yes.
But how is the procedure so Jeff is going to talk to whom?
I'm just not, my understanding had been that zoning needed to make its ruling before it could go in front of ARB. I mean, I recognize that this is a historic home and the historic nature of it may in fact take precedence, but I had always understood.
I think that's
But-
the usual process, but not that, but it's not that you can't do it the other way around.
Okay,
Well, I will check the code to confirm that for you though.
I think the building department is, who determines this? The building department, correct? Jeff?
Correct.
Well, since there's been a little upheaval there, maybe we could check back.
Well, I'll check the code for whether or not there is anything that indicates it has to come before BZA first. And I can follow up with the building department, but also with the representative of the applicant.
Jeff, do we want to talk about minutes now that we have a work session and can perhaps catch up on approving minutes?
Sure, the only concern I have, Mr. Chairman, is I want to make sure that the board has all of the prior minutes before it. And I don't know that the members do. So I'll follow up again if I may.
Do we
With those who've
actually,
taken the
is it
minutes.
legal not, do we have to approve them? I was trained, to do not.
Under the code, there is a procedure for the minutes to be submitted for approval. The issue is that minutes have to be available to the public. And whether they're approved or unapproved, within approximately 30 days, they should be available to the public. So whether or not the board approves them, and that I believe that there's a procedure for that to happen. The board does not have to, but even if not, even unapproved minutes should become available for public review.
So I went to municipal training and it was made, I hear what you're saying, and that's what I was told, that it's absolutely, it is not required that you approve them. There's a legal thing that you have to post them, but that's a whole different matter to me. Could we do it going forward from now and not go backwards?
Well, I think there's two different forms of minutes and I'll forward them all to you so that it's easier to, once you have them in front of you. For the past couple of months, we had prepared shorter versions of the minutes, which I think members of the board were more comfortable with. And prior to that, there were more extensive minutes, which I think members of the board had expressed some concern about, but which should still nonetheless be available to the public. So what I could do is just put everything together. The board could take a look and then either approve or not, and then they can just be available to the public.
But so there is no requirement that we approve prior minutes, so we can choose to let the minutes go public without approval. Let me go back just for everybody's review. I think what was happening with our minutes and the reason why we were holding off on approving them is because they were going into details which were, possibly not details that everybody agreed actually happened in the meeting, but we're at the same time we were having, actual transcripts. So what was the point of having minutes when we had actual transcripts? And so we reviewed the code and realized that the minutes were going into more detail than necessary, and we're going into more detail than other jurisdictions were providing. So we opted to change the format of the minutes and essentially record the votes and nothing more. And that's how we're supposed to be going forward, where there will be a record provided by the minutes of votes, but will not try to summarize the applicant's presentation or the board's review of the presentation, which seemed to, have some editing that was, advisable and in some cases, not helpful for anybody reading those minutes to get a clear view. The best way for anybody to understand what's going on at these meetings, frankly, is to watch the videos, which are also available online. So the idea of detailed minutes, seems like an unnecessary step. But what we want going forward is minutes that are, we can term it skeletal, but essentially it's only supposed to record the votes. Is that a good way to look at it, Jeffrey?
Yes, I agree.
So to Susan's point, I don't want to spend a lot of time going back and having the board review minutes that don't need to be approved. It just doesn't seem important or necessary. So
I
why
don't-
do it?
I can't, why should we're gonna have to then rewatch, to really approve something that's months ago? I'm not willing to look at the video and spend all this time on it. Can't we just, I feel like if we said, okay, starting at the next meeting, or that we just go forward and that we have the skeletal, it's true, when I went to the training, it's to record who was there and who voted and how did they vote. I agree with that completely. Other kind of interpretations of what's going on is not acceptable to me, and therefore I would never approve those minutes. So
What minutes? Right, just to be clear, what's required to be included in minutes would be motions, proposals, resolutions, and any other matter that's formally voted upon by the board, and the actual vote of the board. Those are the required elements.
Right.
So going forward, Jeffrey, if those are if that's the beginning and end of the minutes, then this board will quickly approve them. You said motions, proposals.
Resolutions, any
Outcomes.
other matter formally voted upon by the board and the actual vote, who voted for what.
Okay, so why don't we just have that starting at the next public hearing? Do we need minutes for work sessions at all?
Minutes should be taken at each meeting of the board. Yes.
But we're not voting.
But who attended? Based on what Jeff is saying, I think that it's fundamentally just who would have attended a work session.
The issue
But I
is
have a
that
question about the recordings and how long will they be maintained? And what is the lifetime of these? And I'm in
Well,
total
the-
agreement that minutes should only be recording outcomes, attendance and outcomes.
right, the public officers law requires minutes at every meeting of a public body. So regardless of whether they're extensive or not, they would need to be taken. In terms of the manner in which, your question was, how long do we have to keep the video?
Yeah,
One thing to bear in mind is that the law that was passed requires that this meeting and all meetings of the board be subsequently transcribed, so that there will be a verbatim transcript of the meeting. That's a part of the law that was put into place, and it's now in effect until January. And it's consistent with the prior executive order that was in place during COVID. I would quite frankly need to check. There is a record keeping practice issued through the state of New York as to all records, and I could see if videos would need to be maintained for a particular period of time. But I would expect that records as well as transcripts of the board, but bear in mind that this will be reduced to a transcript, or will need to be at some point.
Will all of the videos are turned into transcripts? Or
The,
just under this?
it's under the laws as was passed, which is consistent with what the executive order said. The executive order had the same language.
The executive order for Zoom or for
During the
during the
pandemic, the executive
Okay.
order, its language was
Okay,
almost identical with this.
okay. But but the video is considered the public record?
The video is a public
Except during
record, as would
COVID?
be the transcript. Yes,
And is the village required to make that available to the public in a timely fashion? Is there a rule about that?
it should be well, yes, the video, the recording
Yeah.
should, I would suggest should be available for people to look at, although it's available immediately, within to be consistent with when minutes are available, it would be within 10 days.
Okay, thank you.
But let me
Okay,
go back to
just
one
as a
point,
final-
Jeffrey. With,
I'm
with
sorry.
respect to the work session, and I have the list, motions, proposals, resolutions, and anything formally, now I'm paraphrasing, formally passed by the board, but we wouldn't do that at any of the work sessions. So why, again, just to understand, why would we have minutes for work sessions if the work sessions don't have minutes, have motions, proposals, resolutions, or anything formal being passed?
Well, but partly because the public officers law says that it's required, we have to have minutes. Secondly, I would include in a proposal something as simple as matter adjourned to next session, decision to be prepared for next session. I would categorize that as a proposal.
Okay,
Agreed. Yeah, and a lot of this is, I think, more for, Jolie and Antoinette, so that we know what the minutes are supposed to look like, and then we can simply look at them and approve them more quickly going forward.
My understanding from this conversation, though, is that there are going to be 3 versions of the exact same meeting. There will be a video, there'll be it'll be completely transcribed, and we will have minutes, correct? How
That's
that
correct.
doesn't seem like it's gonna become bungled in some way is surprising. And who's doing the transcription? Is that being done in-house, or is that is that some kind of service that is provided through Zoom?
I do not know, and I'll have to find out for you.
Okay, because in terms of like, honestly, the idea of the attendance, motions, and then the recording of the vote, that seems like a summary of the transcription that will be created. Seems like a lot of documentation for the exact same meetings. I guess that's government.
That's,
It seems like a lot. I mean, honestly, the
That is-
minutes don't seem
I can't-
necessary if you've got the other 2 pieces in this. edit.
understood, but we have the 2 laws, the public officers law that requires the minutes, and the recent law passed by the state legislature that requires the transcription following an virtual hearing.
But to your point, Julia, that's exactly why we evolved to have the minutes be more streamlined, bare bones, skeletal, and just have, basically a paragraph or 2, listing the motions and the proposals, resolutions, and any formal votes.
A lot of work.
So that's what we have as far as our agenda is. Are there any other matters that any board members want to bring up? Any concerns? Chick, do you have anything?
I don't at this time, Mr. Chairman.
Great, so let's wrap up the work session and we'll see everybody. It's next Thursday at 6 p.m. and it's also via Zoom,
Yes,
correct?
you need a motion to close the meeting, Mark?
Yes, motion to close the work session.
I move that we close the work session of September 14th, 2021 for the Zoning Board of Appeals of the Village of Southampton.
Second.
Aye.
All in favor? Aye.
Bye.